Hello, everyone. We're live from the Carpenter Law Firm studios. And today's topic is assessment collection challenges for 2025. I am going to go through these things. We've talked about a little bit this year, but I want to kind of go back through them a little bit one at a time. So again, the environment is that the legislature has decided to devote special attention to the assessment collection process, and especially to devote special attention to planned community assessment collection processes, and not so much to condominiums, which is a bit strange because assessments tend to be higher in condominiums than in planned communities. And in fact, where we see more intense challenges are in condominiums. I believe this is an oversight and an accident of the legislative process, but let's go through it. So the legislature believes there are problems, and let's remind ourselves what the legislature is. The legislature is 90 people, 60 in the House, 30 in the Senate. There are 30 legislative districts in the state of Arizona. 2 each go there for the House, and 1 per district go there for the Senate. That makes 90 legislators plus the governor. So there are 91 lawmakers, as we tend to call them. So of these 91 lawmakers, the hive mind of the legislature, and if you remember how a bill becomes a law, a bill is proposed in the House, it passes the House, it goes to the Senate, it passes the Senate by majority vote. Of the 30 senators, 16 to pass. Of the 60 House members, 31 to pass. And if it passes the House and the Senate and goes to the governor, and if she signs it, that's how a bill becomes a law. A somewhat simple process, but a lot of negotiating and bartering and back and forth that goes on between these 91 people who also have other priorities and other reasons that they go to the legislature. They don't all go there to reform HOAs, although some do, but many of them need a core issue. Do they go there to reform education? Do they go there to reform the budget? Do they go there to deal with water issues? But some go there to deal with the problem of HOAs. And one of the problems, and I don't necessarily agree with this, having been a volunteer lobbyist for as long as I've been practicing law in Arizona, back to the early 90s, is that there will always be a sob story. There will always be a situation where a homeowner got into financial trouble, fell behind on their assessments, and that owner can turn that situation into a story, into a situation where the owner felt that they were wronged, or that the association was too heavy-handed or too aggressive. So depending on how the story goes, because remember, we legislate by anecdote in Arizona. Many states that regulate associations also legislate by anecdote, meaning a homeowner tells a story, an anecdote, therefore there ought to be a law. That's how we do it. There ought to be a law because there's a story, because there's an anecdote. So because of the stories that are told, many of them secondhand. A story is told to a homeowner advocate who tells the story to the legislator. The legislature, the hive mind, these 91 people, they believe there are problems. And the problems are that the community is not community-minded enough. The community is not the last social safety net for people who fall into trouble. Now, wouldn't it be wonderful if that were true? That the community association would be the last social safety net for people who run into trouble. Well, how wonderful that would be. But the law does not require that. The law requires everybody to pay their fair share of the common expenses. But there is no law or statute that says that when a community member runs into trouble, that everyone else is there to bail them out. That's community forced on community. That's not the way the law works in America. So the legislature believes there are problems. We in the association side expect owners to pay assessments, late charges, fines, collection costs, and attorney's fees incurred in collecting unpaid assessments and related fees and charges. That's our expectation. And the law backs us up on that. The statutes and the case law and the governing documents all say that. That is our expectation. And the legislature has enacted statutes that are consistent with that. So when a homeowner comes along and tells their story that they've been treated unfairly, they tend to tell a story that they've been treated unfairly because the association expects that, expects all the owners to pay what they owe. One of the things that is mind-boggling about how the legislature reacts is that when I talk to legislators and I say, well, you know that associations have one source of revenue, assessments paid by the owners. There's no other source of revenue. Nobody else pays. That's it. There may be a handful of associations that are in the food and beverage business or that rent their clubhouse for public events. But if we were to open the chat in this webinar for people to name specific associations that rent their clubhouse because you've been there and you know that, we could probably name 2 or 3 in the entire state where we've been to events because the association rents its clubhouse for public events. It is not fair for legislators to believe that when an association runs into trouble because of high delinquencies, oh, that's okay. The association has another source of revenue. They'll make it up selling branded t-shirts, selling widgets, or some other source of revenue. We know this. We on this side of the realm, that when people don't pay, it's a crisis. The roofs don't get maintained. The common areas are not maintained. Scheduled maintenance is not done on time. And the cascading effects are serious. I've had clients where the annual insurance premium couldn't be paid. You know, that's how this works. And there's no way to absorb the looming expenses when people don't pay. Associations essentially operate on the honor system. People will pay when they're obligated to pay, and when they don't, it creates a cascading crisis. Legislators who believe that the association is being heavy-handed when it expects people to pay fundamentally either do not understand this one source of revenue rule or don't want to understand it. They want to believe that associations that want people to pay are kind of like aggressive credit card companies who just want people to pay their credit card debt and are mean about it. So we're up against a difficult environment at the legislature with these 90 legislators who kind of have it in their head that the association is the bad guy for expecting to be paid. And as you all know, of course, associations work from an approved budget. The budget is almost always, I shouldn't say it that way. Often association boards work from the revenue first. We're only going to have so much revenue because we start with an assessment amount that's set, because boards do not want to raise the assessment. Instead of starting from the expense side, because expenses always go up. Inflation has been around now for nearly 5 years, since the beginning of the pandemic. I don't want to overstate it. 3-4 years. You all know better than I do. I know that legal fees have gone up significantly since the beginning of the pandemic. Our costs as a business go up. Attorney wages for the attorneys that work in law firms have gone up significantly for complicated reasons that have to do with student loan debt in law schools and other reasons. And so we end up in a world where, and I've noticed it from the outside, my clients, the associations, they tend to start the budgeting process from, we're only going to have so much revenue, instead of, well, we know the expenses are going to go up, and then building the revenue side once we've established the expense side. If we did it that way more often, we would know the assessments have to go up, because the assessments should be going up every year. But I often see my clients struggling with, and it's really the professional community managers struggle a bit with boards that box in the budget with the assumption the assessments can't go up for whatever odd reason, political often. And then we ask this question, when we look at all of this environment, and forget about the board and the approved budget and that dynamic that tends to happen across the country, with the legislature having all of these assumptions and beliefs, did the legislature convene a data collection task force to study the depth of the problem? I mean, the legislature believes all of these things, the hive mind of the 90 legislators about how all of this is happening and the abuses that are going on with the collection of assessments, both at the association side and by lawyers, once we get a hold of it. Did the legislature convene a data collection task force to study the depth of the problem and come to these conclusions? And you can see it there on the screen. No, they didn't. They just somehow have these conclusions, but there has been no task force to study the problem and to do a deep dive into the data and figure out what is the problem, how did it happen, who are the bad actors, and what can be done about it from a public policy standpoint. So, what is the problem? Well, owners who don't pay ultimately are sued in court. That's how you collect money from people who owe it in an environment where money is owed and not paid. If I run up a huge credit card bill and I don't pay it, I will ultimately be sued. If I go to the Ford dealership and buy the F-150 that I've got my eye on and I don't pay it, I will likely suffer two consequences. If I borrow the money for it from Ford Credit and I don't make the payments, the truck will be repossessed from my driveway. And if there's a deficiency between the amount the car is worth when they auction it off after the repossession and the amount that I owe, let's make up some numbers. Let's say I borrow 70 grand for the truck and they auction it and they only get 50 grand at the auction. That's a deficiency of 20 grand. I still owe 70, let's say. They auction it for 50. I still owe 20. I will be sued for the 20 in court, I will lose. There will be a judgment entered against me for 20 grand. It'll be entered against me personally because they already have the collateral. They repossessed it from my driveway. The collateral's gone, but I owed 70. The collateral was only worth 50. I will be sued for 20 and I will lose. That's what's happening in our HOA world is if an owner is sued in court, we can sue them personally for the debt, which is the equivalent of Ford Credit suing me for the 20. I owe it personally. I signed the papers at the Ford dealership, but the association can also take the collateral, which is a foreclosure lawsuit, which is the equivalent of the truck being repossessed from my driveway. Taking the collateral because the association assessment the assessment obligation is secured by the collateral, which is the house, and I owe it personally. In my HOA at Greenfield and Guadalupe, I owe the assessments personally, and my house is collateral for the assessment obligation. So associations make a choice, and the lawyers that are hired by associations make a choice. Do we want to sue the homeowner personally and get a judgment against them, either in justice court, small claims court, or superior court, depending on the amount that's owed? Or do we want to take the collateral that secures the assessment obligation, which is the equivalent of repossessing the F-150 in my driveway? And sometimes we don't think of it that way, but that's what's happening. That's the equivalent of what's happening using my F-150 example. We can repossess the truck, we can have the house sold to satisfy the debt, or we can sue the person individually, personally. So the problem is owners are sued in court either way, either personally or to repossess not repossess, but to have the collateral sold to satisfy the delinquency. Part of the other problem is lawyers charge legal fees. Legislators don't love that. Owners are then obligated to pay the assessments, the late charges, interest sometimes, and then the legal fees on top of it, under the theory that without the owner being delinquent, the legal fees wouldn't have been incurred, and the bad actor, the one who didn't pay, should be obligated to pay the association the legal fees that were incurred by the association because of the delinquency. So that's part of the problem too. And then courts, judges, sometimes we use the word judge in court as a synonym. Courts impose those legal fees on the delinquent owners. So you can put all of this in the category of the problem, because owners who do not pay dislike this result. Who would like it? You owe the association $2,000 in unpaid assessments. You don't pay it. When you finally realize you do have to pay it, your preference would be to just pay the $2,000 and not have to pay, I'll make up a number, $3,000 in legal fees on top of it. You'd rather pay the $2,000 and not $5,000. But what ends up happening is the association hired the Carpenter law firm, let's say, in this example. I sent 2 letters. I filed a foreclosure lawsuit. And only because of the foreclosure lawsuit did the owner wake up and realize the association is serious. And then we're 3 months into a foreclosure lawsuit, and then the owner finally, miraculously, finds the money. They've ignored you. They ignored the association. They ignored the management company. They ignored every other communication. And then the slow moving freight train of foreclosure that can't be stopped, the repossession of the truck in the driveway, as I've called it, all of a sudden you have an epiphany. Oh my goodness, I talked to an attorney. I have a cousin who's an attorney. They've looked at it and they've told me, you better find the money. It's 2,000 plus 3,000 in attorney's fees. If you don't pay the 5,000, you're going to lose your house. So owners who do not pay dislike this result because the foreclosure will happen. So when we get to this point in the lawsuit, not very far along actually in most cases, the owner would rather pay the original amount to the delinquency and be done. Hey, I'd rather just pay the 2,000. And this has happened in a number of cases that I'm handling recently where an owner realizes, hey, I got served with the foreclosure lawsuit. We're a couple of months in, but I still have this original letter that I ignored. I found it here in my paperwork. I did receive it. The original number is $2,000. I think I'll go to this Carpenter law firm website and pay the $2,000 and hope that does it. And I'm sorry to chuckle during this webinar. And they sneak a payment in on my website for the $2,000, thinking, well, maybe this will all go away if I pay the original amount. And alas, that doesn't work. We're in a lawsuit. We are going to go straight to the judge and ask the judge for a judgment for $5,000 with the $2,000 payment as a credit. So we get a foreclosure judgment for $3,000. I mean, the math is actually pretty simple, but the homeowner cannot push it to the point of a $5,000 payoff, sneak a $2,000 payment in on the payment portal on my website and think it's all going to go away. It's not how it works. So we end up in these somewhat weird situations. And I've had debtors, homeowners, play the same game with management company payment portal websites also. It's not that complicated. But this last bullet point is something that rational people like to play games with. Hey, I have this original number from the last letter I got from the management company. I think I'll pay that. I'll just go to the management company's website. Now, of course, we want the management companies to close off the homeowner from making payments when the account is at the law firm, but that's a technical matter for a different day. So this is the problem when we end up with the status of collections today in 2025. Homeowners would rather pay the original delinquency and be done. So what we end up with is owners complain to the legislator because they don't like any of this. This is all a situation they would rather not be involved in. Now, how does this happen? We'll stop here for a moment and ask the question. How did we get here in 2025? Not 2025, 2025. Owners who don't want to end up here sign up for ACH and automatic payments with the management company. That's what I do. I've been doing it for 30 years and I've lived in HOAs my entire time in Arizona. Representing HOAs, I realized from day one, make automatic payments so that there's no chance you could ever miss a month writing a paper check. Auto pay is the only way to do this. So people who don't get on auto pay end up in this situation. That's one category of how people get into trouble, is where they don't sign up for auto pay. The second category of how people get into trouble is the possibility that we're seeing a a problem with the economy. You know, some of us were around, not everybody on the webinar, of course, but some of us were around when the bottom fell out in 2008 and 2009. It started with a trickle, and before we knew it, it was a full-fledged Great Recession. And it's possible that we're seeing, in some cases, um, the economy starting to have trouble, where people are losing their jobs and actually don't have the money. And remember, there are two rules of debt collection that have never changed across all cultures and across all languages. Rule number one, you can't get money from people who don't have it. And the longer you wait to be paid, the less likely you are to be paid. So it could be rule number one, people don't have the money. And when they do make these payments, and they go to a website and they sneak a payment in on my portal or a management company portal, they've cobbled the money together from family members or from a credit card or something like that. And you know, we're thankful that they paid us first, but there may be a more catastrophic uh, financial problem going on for this homeowner or family. And it's possible that under rule number one, you can't get money from people who don't have it. There may be something going on there. Again, it's not our problem. It's not our responsibility to fix it. Homeownership may be incompatible with that person's stage of life, stage of economic um, mobility at the moment. And that's not the association's job to fix that or to save them from that stage of their life. Sometimes people lose their job and they lose their home at the same time. And the association is not legally obligated to rescue people from a stage of life that's difficult. So when people complain to the legislator, it is not the legislature's job to ensure that every homeowner who's ever been a homeowner continue to be a homeowner in that home for the rest of their life. So in 2024, there were some bills that passed the House, a bill that passed the House 56-0, and in the Senate 28-0. The topic is a good bet for legislative success. So when this happened in 2024, and we're still kind of feeling this, you know that there's a sentiment in the legislature to regulate community associations, 56-0, and the Senate 28-0. So when we deal with collections, there are two types of contingency arrangements that we see from lawyers. I want to go through them quickly. One I call personal injury contingency. A lawyer takes 1/3 of the principal. Let's say 900 is owed to the association. On the lawyer's very best day in collecting the 900, the lawyer gets $300. We don't see this much in Arizona HOA collection activity because of the economics of how debt collection works, hourly rates, and the amount of effort that it takes. I don't know any lawyers in Arizona that are doing personal injury contingency on small dollar collections, where on my very best day, I would do a lot of work for 1/3 of the total delinquency. You can see there, that'd be tough. That'd be very tough for me to stay in business if I worked for 1/3 of the principal. Now, if it was a high principal, I might be more willing to do it. I'm chuckling a little bit because you can see that it's not very likely that you're going to find a law firm willing to partner in the work at a 1/3 of the principal personal injury contingency. And then the other type that you see from time to time is attorney's fees on top contingency. 900 is owed to the association. And let's say the attorney incurs $1,500 in attorney's fees for collecting the 900. The owner pays 2,400 because the attorney's fees are stacked on top of the 900. The lawyer collects 2,400 from the owner, a more typical contingency arrangement that we've seen since the Great Recession, where attorney's fees on top contingency has prevailed as a more likely partnership between client and law firm in contingency arrangement moving forward on um, collecting delinquent assessments. Pretty typical. And the legislature doesn't care about, at least they have not regulated out of existence attorney's fees on top contingency. Although I will footnote here that in the state of Texas, where I grew up and where I'm also licensed, haven't practiced much there, that in the state of Texas, type 2 attorney's fees on top contingency is prohibited by statute. And type 1 is also prohibited by statute. The Texas legislature has decided that no contingency arrangement for debt collection is permissible in Texas Community Association debt collection. Only fee for service is permissible in Texas. So for those of you who have managed in Texas, you're likely aware of this. All right, so a couple of more thoughts. In 2024, the legislature started their march toward the solution to some of these problems. Representative Neil Carter attacked personal injury contingency collections and said that reasonable attorney's fees are only included in the statutory lien if awarded by a court. So, we've got to be careful there as lawyers that we may need to keep going, sue early, sue often, always go to trial. And the idea in 2024 that we were concerned about was we have to get judgments in order to get our reasonable attorney's fees included in the statutory lien if awarded by a court. So what we were concerned about in 2024 last year was this idea that we need to sue early, sue often, always go to trial, never settle, and get these fees included if awarded by a court and go to trial. We've somewhat moderated that position now, given that attorney's fees are included in the lien provided in the governing documents. So this idea that we always have to get our award sanctioned by a judge and go all the way to in front of a judge, we're not so concerned about that so much. And then this year, we have Senate Bill 1494 for planned communities only, which I had mentioned earlier, does not apply to condominiums. And it says that a common expense lien can be foreclosed only if the owner has been and remains delinquent in the payment of assessments or portion of assessments for a period of 18 months or $10,000 or more, whichever occurs first, as determined on the date the foreclosure lawsuit is filed with Superior Court. So what's happened with this is the first thing that's happened is we focus a bit on the $10,000. In a planned community, letting someone's delinquency get to $10,000 would be problematic. But if someone's been delinquent for 18 months, we can still foreclose. Now that would be problematic as well, to let someone be delinquent that long, but we can still foreclose in planned communities. But this bill 1494 in the 2025 legislative session did not impact assessment collections in condominiums. it was just for planned communities, and I think it was an oversight, as I mentioned earlier. Usually what happens at the legislature is when someone complains, tells their story, their anecdote, and it results in a regulatory change, the change is mirrored in the planned community statutes and the condominium act, that this one did not make it into that mirrored regulatory structure for some reason. We don't know why. My suspicion is that whoever told the story, whoever complained, lived in a planned community and it just never got in the memo. Nobody ever said, well, we should also put this in the condominium act. So there is no need to wait 18 months. We still have the 12 months and the $1,200 threshold in the condominium act, but not 18 months or $10,000. So in a condominium, if someone's been delinquent for 12 months or $1,200, we can move forward in a condominium. But there's a special rule now for a planned community. We had to file foreclosures before September 26th. If we miss that, it's okay. We can still, figure out what to do. We can still, send our letters, and there's a couple of other things we can do, which I'll mention in the next few minutes here before we wrap up. We were filing foreclosures with a vengeance before September 26th, which was the effective date of the legislation. But that's now gone. We're in October 21st, 2025, the date of this webinar. And so this is no longer possible. We can't get in our time machine and go back and file foreclosures. So that was the effective date of Senate Bill 1494. All right, so what can we do moving forward? Small claims court is available for associations where the delinquency is below $5,000. Attorneys cannot appear in small claims court. I could sue a client who hasn't paid my bill because I'm appearing on behalf of my own business, but I cannot appear on behalf of a client in small claims court. I'm prohibited. Small claims court is a place that is for people to go for disputes where lawyers are not allowed. Oddly, small claims court is in the same courtroom, in the same courthouse as the justice court, where I can go. And I've been many times. But attorneys cannot appear in small claims court on behalf of a client. I can go on behalf of my own business if I have a dispute. In my personal life, I can go on behalf of my own personal business, but I cannot appear on behalf of a client. If you go there, you can obtain a personal money judgment, the equivalent of the $20,000 deficiency judgment in my F-150 example. I owe Ford Credit $70,000. The F-150 sold at auction after repossession for $50,000. I still owe Ford Credit 20 grand. That's more than $5,000. Ford Credit would not go to small claims court, but I'm trying to make the point that I personally owe Ford Credit 20 grand. If a homeowner owes the association 3 grand, the association could go to small claims court for the $3,000, and you could obtain a personal money judgment. A personal money judgment could be used to garnish wages or garnish a bank account. In 2022, here in Arizona, the citizens adopted Prop 209. You may remember at the time it was supposedly done to limit healthcare debt, that when you go to the hospital and you run up a big emergency room bill, that the hospital couldn't garnish your wages. Well, it wasn't a bait and switch necessarily. It ended up being true that if you go to the ER and you run up a $50,000 bill, a hospital that gets a personal money judgment against you could not, cannot garnish your wages for more than 10% of disposable income. The law did change for them, but it also changed for us. So a small claims court judgment that used to be 25% of disposable income and a pretty good tool for us that get judgments is now limited to 10% of disposable income. So a small claims court judgment, you can get 10% of disposable income. You can also garnish a bank account, but unless someone has paid their assessments with a check and you've kept a copy of the check so that you can use it to identify a bank account where you can garnish. But now you're back using lawyers again, and now you're incurring legal fees to garnish wages and garnish a bank account. And part of the idea of small claims court is not to incur legal fees. But we're always happy to help. But part of the goal is to do it without lots of legal fees. Justice court, same courtroom, same courthouse, for amounts below 10 grand. Attorneys can appear, but you also get a personal money judgment to garnish wages or garnish a bank account. Now, remember that a lot of people own homes and do not have a W-2 type job with wages. They might be an independent contractor, they might be a realtor, they might originate mortgages, and they might be a consultant, they might own a law firm and have inconsistent income, or they might get a K-1 through a partnership, and they might not keep a lot of money in a bank account. They might get money from an IRA distribution or a 401k distribution, and those are protected. You cannot garnish an IRA or a 401k. So these money judgments, they sound good in a webinar, but some are protected, kind of like your homestead. So you cannot take a money judgment and execute it against someone's homestead and get the equity in their home. Garnishing wages, you have to know where they work too, which is not always easy, and garnishing a bank account. So here with the Justice Court judgment, we have the same Prop 209 issue. So hiring an attorney to get Justice Court judgments has been more complicated since 2022, and it's not the primary modus operandi of lawyers today to spend a lot of time and effort and money getting personal money judgments, only to run into this 10% wage garnishment problem and bank account problem where we don't necessarily know where someone banks. I'm not trying to be negative about it, but what used to be the mainstay of assessment collections in Arizona, getting Justice Court judgments and garnishing wages and bank accounts, has become more difficult, mostly because the legislature seems to want associations to foreclose, sort of by the way that they're regulating and knowing that Prop 209 exists. We end up in this march to foreclosure. The legislature did not enact Prop 209, but Prop 209 existed in 2022 when the legislature started regulating around debt collection, and we end up in this march to foreclosure. Step one, the lawyer sends a demand letter. Step two, now required by the 2024 legislation, a reasonable payment plan. To me, that's 6 months with interest. And then step three, the foreclosure lawsuit that is a slow moving freight train that can't be stopped. So we end up in a situation where no trickery, here's the amount. We'll always settle. We may not compromise. You have to pay the full amount of assessments. You have to pay the legal fees. You have to pay the late charges. We may waive those. The board may be flexible on that. But we may do a 6-month payment plan and as required, reasonable payment plan by the statute. But the association has to be paid. And if the home is no longer affordable and you want to move, that's the homeowner's prerogative. But it's not the association's obligation to make all the other owners chip in and save the home for the homeowner who can't afford it. That's the way we look at it. So looking forward, owners will complain to their legislators. We're going to hear this again and again. HOAs are foreclosing. The assessment lien is unjust. We may hear that again at the legislature. And we may hear calls at the legislature to eliminate the assessment lien. And what would that leave us with? That would leave the Justice Court, the Small Claims Court, and 10% of disposable income, wage garnishments, and bank garnishments, bank account garnishments only. That would be a difficult world to live in for associations, because we see all the time where we sue people in foreclosure, and the only time that we ever get their attention is when we serve the foreclosure lawsuit. And sometimes we only get their attention when they don't answer the lawsuit, and we send them default paperwork. And then all of a sudden, we get a phone call. What's the payoff? What's the number? And using numbers I used earlier, it's $5,000. It was $2,000. Now we've got $3,000 in attorney's fees. Now it's $5,000. And they say, well, will you take $2,500? Like, well, we'll pass it along to the board. But I suspect that since the board's already paid us $3,000 on top of the $2,000 of assessments, the board's going to want the $5,000. And we communicate it back, and nearly every time, all of a sudden, we get a payment on our website portal for $5,000. And I don't mean to be surprised about it the way I'm communicating it, but people generally want to keep the home they live in. And so they find the money. But sometimes people make things unnecessarily expensive. Just earlier this week, we have a foreclosure in my office where an owner filed an answer with the court. She admitted certain things, she denied other things. When you answer a lawsuit, you can only say 3 things to the allegations: admit them, deny them, or say, I have insufficient information to admit or deny. Those are the 3 options. Multiple choice: admit, deny, or I have insufficient information to admit or deny. Well, she admitted so much that we are going to move for what's called motion for judgment on the pleadings. That she admitted so much of it that we should win outright, because she admitted the case. She admitted she's an owner. She admitted the CC&Rs. She admitted the ledger. And we're going to win outright based on the way that she answered the lawsuit. I mean, if you're going to answer the lawsuit, not giving her advice necessarily, but if you're going to answer the lawsuit, say, I admit I'm an owner. The ledger's wrong. I made all the payments. Let's go to trial. I mean, if you think about it in those terms, at least you're answering the lawsuit in a way that makes some sense. I'm an owner. I made all the payments. The ledger's wrong. let's go to trial. That would be a reason to file an answer with the court, but she didn't say any of that. So instead she admitted her entire case. And we're going to move for judgment on the pleadings that she filed. And we're going to end up hopefully with the whole thing just being resolved quickly. So when people don't respond, we win. When they respond, we win. And the cases tend to be resolved pretty easily and quickly. So with that, that's the state of collections in 2025. Hopefully, when the legislature convenes in 2026, we won't see too many crazy bills. There's not much left to do other than I worry about a legislator thinking that associations can survive without an assessment lien. I don't think we can survive without an assessment lien very long, just suing people for judgments and garnishing wages. And I don't think that will work very long. But I'm happy to take some questions in the chat or wherever they seem to work here, if anybody has any. In the webinar format, I can't take questions verbally. If not, I'll close a few minutes before 1. Well, thank you all for participating today. Hopefully this has been helpful, and I'm always available for a question or to chat if you need any help. My website's there on the last slide. My email is scott@carpenter.law. See you next time. Thanks.